I'm going to explain how to file for a divorce in 7 easy steps. Hi, I'm Zachary C. Ashby from Pacific Northwest Family Law. We practice family law throughout the state of Washington. I've got 7 steps for you for starting a divorce in the court so that you can get going with the process. So the first step in any divorce is you do have to determine which county that you're going to file in. But usually it's the county where you live in, because that's where the Superior Court is going to be located. If another spouse lives out of state or in a different county or different part of the state, you've got to decide which of the counties is going to be the right one to have the divorce in. And usually it's going to be where you live, but not always. Another consideration is you can file in any county in the state of Washington by agreement with other parties. Many people will file in Lincoln County, for example, because it's really easy to file there only if it's agreed to. The only problem is if things fall apart along the way or in the future, you got to go to Lincoln County, which can be a little bit out of the way for some folks. So that's why filing in the county where you live is usually going to be the best. Not always, of course. But once you've decided on the county, the next thing you need to do is get the divorce forms from courts.wa.gov. Actually, it's courts. This is the court's website for all Washington state. It includes from the Supreme Court down to district courts. There's a tab at the top that says forms, and you can find the divorce forms there. Another place you can go is Washington lawhelp.org. This is set up by I believe it was a project by Northwest Justice Project years ago, and they have some packets for people who are doing a simple divorce process or who are doing it without attorneys. So you can get all the forms there. By the way, those websites that they're selling you the forms, they're just taking your money. The other place you can go, especially if you want to make sure it gets done quickly and correctly, of course, is hiring an attorney. Whether you have an agreement or not, the attorney will be able to know exactly which forms to file for your situation and help make sure everything goes smoothly so that you can finish quickly and efficiently. But having an attorney, of course, is not required. There are many people who do it without. The next step, of course, is taking these documents and filling them out. The basic documents that you'll need are the petition and the summons. These are the 2 most important. They set things out and they tell people when to go to court and where to serve documents. There are going to be other documents that you might want. If there's children involved, you need a proposed parenting plan. You'll need to do child support worksheets. And then there's some other administrative things that you'll need: a confidential information form, a case cover sheet. You can find all of them at courts.wa.gov or in one of those packets. You got to fill them out. So that's step 3. Step 4 is going to be filing. Usually means you're going to pay a filing fee. Most superior courts, the year 2024 divorce filing fee is $314. If you are below the poverty line, you can apply to have the court fees waived, but not everyone qualifies for that. So it's usually your money and you bring all your documents. By the way, you need at least 2 copies of everything. Usually we'll do 3 copies. When we bring it down, you want the originals where you signed it and everything. Those get filed with the clerk, and if you have copies, the clerk can stamp. They'll check and make sure everything's the same, but stamp everything with the date of the court. Those are called conformed copies. That's the 5th step. What that allows you to do is have a copy that has been stamped by the court. It conforms to the court file. If you have 2 sets, you have a set for yourself to keep so you know what's filed with the court. Because the only person who's going to see those court documents from now on might be the judge and the clerk, but you probably won't ever see those again. It's mostly the petition and summons that you're going to need. Not everything gets served on the other side, but you want to take the documents that do get served: the petition, the summons, proposed parenting plan. So after you have your copies, the next thing you do is serve those documents. What service is, you take those documents and you hand them to the other party. Service can only be done by someone who is over the age of 18 and who is not a party. And it has to be done by hand delivering the documents. Your 17-year-old neighbor can't do it but your 18-year-old coworker could do it. But it could be anyone over the age of 18. Some people will use friends, neighbor, family to do it. It shouldn't be one of your kids, even if they're an adult. Just leave them out. But it could be your parents, could be a brother or sister. You can hire a professional process server to serve the documents, or I think even some sheriff's departments will do it. But usually that's the most costly way to do it. And I'll tell you that that's probably the worst way to start off a divorce is have a sheriff knock on your door and hand you documents. Whoever does serve the documents needs to fill out what's called a proof of service or proof of original service. And what that document says, and again, you can get that from courts.wa.gov. I'm over the age of 18. I served the other party at this address on this date, and these were the documents I served. And then they sign it under oath in writing, and that gets filed with the court. Now that's important because in Washington, you have a minimum of 90 days from service to when you can finalize. And if you have an agreement, then you can file the final documents after those 90 days. Most people will take longer than 90 days to resolve their divorce, but you don't even start that clock at all until you've served. And you need to prove that you've done original service by filing the proof of service. Once you've done that, you've started. You're on your way. Now be careful because you're not done. I have talked to many people who claim that they thought they were divorced because they either got served with documents or they filed the documents and they thought that's all you had to do and the process would take care of itself. If no one shows up to a status conference or settlement or anything else that's scheduled, the court will just dismiss the whole thing and you have to start over again. So you have to pay attention to any scheduling orders or any other things that the court tells you have to show up to. Better show up to it. Most divorces end in an agreement, but that agreement often takes a lot of work to get to. It often will take a mediation with a professional mediator to reach an agreement. And some people have to go to trial and argue and take their chances that the judge is actually going to see it their way and they won't see it the other party's way. By the way, part of what the judges are trying to do, unless it's very crystal clear, because you have a very unique case, so the judge will probably just try and make both sides mad or just split things down the middle or take a little bit of what they want, a little bit of what you want, and try and give you each a little bit of what you want. But you can't control the outcome. The only way you control the outcome is agreement, but that's for a different video. If this one helped you, please share, comment below if you have a question. If you would like to see how we can help you with the divorce process, please give us a call at 509-866-4111. Thank you.